I only had about 100.
I know, I was upset. I started crying. I saw a lot of Batman. I saw one Godzilla, a lot of princesses, a lot of zombies.
No clowns?
I'm sorry?
Oh, you were a clown.
I was a clown. Hardly any clowns. The one clown I saw had spiked teeth.
Yeah, there was a lot of those in Chinling.
What was that? That's not a... Clowns are supposed to be funny, not evil. But I think there's a whole movement about evil stuff. Oh, I'm already... Let's talk about costumes. What are we talking about? Scope of forensic psychology. This is a new direction in forensic psychology. Forensic psychology started out as working with the police department. Not so much anymore. It's more working with the law courts. The law courts. Anyway, then that's primarily what we're going to talk about today. Moses, your house. Are you okay? Forensic assessment activities are typically performed by clinical psychologists. The field has prospered in the last 30 years. It's expanding, and as I said before, forensic psychology used to be part of the police department, and now it is doing evaluation. We've already talked about profiling. These individuals profile, this is a cleaner group of individuals. If you're a profiler, you have to deal with a lot of crime scenes. You're dealing with a lot of individuals that have committed a crime. In this case, it's cleaner. So you're working with lawyers, you're working with their clients, and usually they're on their best behavior. So you're not really going to see them at their worst, their gory, bloody worst. You're only going to see them on their best behavior. Usually that's what's going to happen. And that's what we're going to talk about today. So the forensics that we were talking about before, where you're criminal profiling, you're not actually going to be doing that as far as this is concerned. Forensic psychology is recognized as a specialty by the American Board of Professional Psychology and by the APA, the American Psychological Association. And I can't remember which division it is. There are 48 different psychological divisions, and this is one of them, actually. Revised specialty guidelines for the practice of forensic psychology has been approved by both organizations. Forensic psychology pre-doctoral training concentrations and postdoctoral fellowships are available, providing formal training in the field. And usually training in the field means evaluating people when you're dealing with whether they are competent to stand trial or not. The research and clinical literature on forensic practice has increased dramatically. The other thing that you need to know about these individuals is they make a lot of money. And that's really important to people. And they stay clean. They don't have to walk around in gory, bloody crime scenes. Usually these individuals stay away from that. They are not profilers. We already talked about profilers. Growth in this field is likely to continue, mainly because mental health experts may have the expertise in a variety of areas relevant to litigation. This has to do with lawyers. And lawyers don't like to get dirty either. Lawyers don't like to walk around crime scenes either. The law permits and even encourages the use of expert testimony on psychological topics. Expert testimony by forensic psychologists thrives because it can be very lucrative. And of course, all you need to do is watch Bull, and you can see exactly how lucrative it can possibly be. Phil McGraw, it's actually a television show about Phil McGraw, a multi-millionaire mainly because of his ability to read juries. So he would be hired by wealthy individuals to read juries. And that's, of course, one thing that you don't see in the television show is the fact that this guy's making money hand over fist. He's making buckets and buckets of money and living a very expensive lifestyle. In general, a qualified expert can testify about a topic if such testimony is relevant to an issue in dispute, and if the usefulness of the testimony outweighs whatever prejudicial impact it might have. The United States Supreme Court ruled in 1993, in the case of Daubert versus Merrill Dow, that federal judges can decide whether expert testimony has a sufficiently relevant and reliable scientific foundation to be admitted into evidence. There are judges that do not believe in this stuff, and you will not be able to present this material in their courts. They won't allow it. But there are judges out there that do accept it. So the question is psychology a science? And if we asked that of Sarah, she would tell you definitely it's a science. It's very definitely a science, definitely a science, definitely a science. But the reality is there's a lot of art in psychology, tons of art in psychology. A lot of times we're quantifying things that maybe shouldn't be quantified. On a scale of 1 to 10, that's a 5. Really? And if we ask somebody else, it's a 3. What's going on here? Is this really an accurate quantification? And the answer is, depression is my favorite. On a scale of 1 to 5, how depressed are you? How sad do you feel?
Sorry, face.
Yeah. And one of those faces in between. Let me look in a mirror and I'll tell you exactly how I feel. Example, let me give you an example. This is a famous case. It's one of the most controversial cases that has ever come up. The question was, should Andrea Yates, should she stand trial? If you remember Andrea Yates, she was, she drowned her 5 children in the bathtub. What a way to go, huh? And then she laid them all out, really kind of strange. Then she called the cops and said, I just killed my children. As exciting as that is. Now the interesting thing about Andrea Yates is that she had a long history of depression. She'd been diagnosed as psychotic after her 4th child. This is postpartum psychosis. We're not talking about postpartum depression where you got the baby blues. This is a lot more severe than that. When I was working in the hospital, I had an individual working for me, and his wife was pregnant. He said, she's kind of grouchy. She's kind of grouchy. She kept talking about how grouchy his wife was. And I said, she should be fine. She should be fine. Don't worry about it. And he would come to work, and sometimes he would have a really serious look on his face. You know, he was a happy guy. He was a really pleasant fellow. But sometimes he'd come to work, and he just had a horrible look on his face. I said, what's going on? He said, my wife, she seems to be getting worse and worse and worse. I said, well, what's wrong? She said, she's so depressed all the time. Well, it's just the hormones. Let's see what happens. As it turned out, she had the baby, and the first time they gave her the baby, she dropped it. And that was the last time she saw the baby, because they were afraid she was going to do the baby harm. She went completely insane. She became psychotic. And she's still in the hospital. Last I heard, she was still in the hospital, and that was 15 years after she had the baby. She's psychotic. She's schizophrenic. It had kicked her into schizophrenia. These kinds of things can happen. It has to do with the structure of the brain. This individual had been depressed all of her life. So having the baby blues was fairly common. She was having baby after baby after baby after baby. She was pregnant all the time. Andrea Yates. As you can see, they're stair-stepped kids. So she was getting pregnant every year. The individual that I'm talking about, that was her first baby. Her first baby kicked her into psychosis. And last I heard, she was still in the hospital. And she'd only seen the baby the one time. She dropped the baby when it was the first time she saw it. She was laying in the bed, and she had the baby, and she just pushed it right off. I know, it sounds horrible. Anyway, and her husband was devastated because before he had a wife and potentially a new baby, and now he only had a new baby. And he didn't know how to take care of babies. He'd never taken care of babies before. So, and he didn't have a wife to help him. And he was all devastated as to what happened. And of course, she was hospitalized. and he had to visit her. And the one thing that they told him not to talk about was the baby, even if she mentioned the baby. Don't say anything. Use one-word answers. She's okay. If the wife asked him, but she never did. She never asked him about the baby. What she wanted to talk about was when they were dating. And evidently they had premarital sex, which in their religion was not kosher, was not legal, and that's what she was obsessed with. This idea that she had premarital sex, which potentially tainted the baby, of course, because they had sex before they were married. God couldn't bless their union or whatever. Anyway, she didn't get pregnant. She got pregnant after they got married. But as far as she was concerned, it was that premarital sex that tainted her, that destroyed her. Anyway, this is Andrea Yates, totally different situation. She had 4 babies, and after the 4th baby, she had a psychotic episode. So she went into postpartum psychosis, but she came out. She had a history of attempting suicide that went all the way back to high school. Andrea Yates was a nurse. She was a registered nurse, and she worked in medicine. And she was a good nurse, and she worked in medicine. Anyway, the Yates were warned not to have a 5th child. They were warned that it might kick her into psychosis. And guess what happened next?
She had a kid anyway?
She got pregnant almost right away. As soon as the doctor told her not to get pregnant again, she got pregnant again. Now you have to ask the question, well, she's psychotic. She was psychotic. So why didn't she have an abortion? What's the answer? What was the answer they gave? Any guesses?
Was it against their religion that they...
It was against their religion. But why was it against their religion? What did they call it? What did that religion call it if you had an abortion? They called it murder. So she didn't want to murder her unborn child. So instead, she had the baby. And when the youngest baby, the young girl, she had 4 boys. And of course, they were very active boys, and it drove her nuts. Well, she was already nuts. Sorry. It drove her crazy. So she had the little girl. She was so happy to have the little girl. About 6 months later, she drowned them all. She drowned all 5 of her babies. So instead of murdering the baby, murdering the child, aborting the child, she murdered all 5 of her children. Now the question was, is she competent to stand trial? That was the question. They found her competent to stand trial. She seemed fairly lucid, relatively lucid, not psychotic at all. She said it was her fault, the reason she had to kill. Does anybody know why she had to kill her children? Does anybody remember the case? Can you remember why she had to kill her children? She was afraid that she was tainted and she couldn't raise them properly, and they would become monsters, which is something that she called them whenever they misbehaved. She called them monsters. And now all of a sudden she decided that she had to do away with the monsters, that she wasn't able to raise monsters. If she raised a child, that the child would turn out to be a monster. So that's why she killed them. She killed all 5 of them, drowned them, and laid them out on the bed. It's kind of neat. Laid them out neatly out on the bed. Anyway, in Texas, they decided that she was able to stand trial on 5 counts of murder. The jury rejected the death penalty, but she was convicted of murder, and they put her in jail for life. It was life imprisonment. A lot of people were upset about this. How in the world could you do this to this woman? How could you do this? In some countries, if you kill your child within 18 months of life, then you're not charged with murder. involuntary manslaughter because of postpartum depression. In England, for example, if you murder your child, infanticide is what it's called. You can do that. A lot of upset people in the United States because of her conviction. They thought that there must be something wrong with her. Wait a minute, we just had a terrorist attack yesterday, right? Some guy in a pickup truck, ran onto a bicycle path and killed 8 bicyclists. That happened yesterday. Was he insane? Is that an insane act? We're talking about competence here. He had 2 guns. One was a pellet gun and the other was a blank pistol.
It was a paintball.
I'm sorry, paintball gun, that's right, thank you, paintball gun and a pellet gun. It's going to do a lot of damage with that paintball. Okay, paintball gun. But they look like real weapons and they shot him. Evidently they shot him in the abdomen, he's still alive, they took him to surgery. Okay, so we'll get to try this guy. Is he crazy? Was he insane? I got two shakes of the head, meaning no. Does everybody else agree he's not crazy? Was she crazy? Okay. Well, that's what everybody thought. So they retried her. Wait a minute, that's double jeopardy. You can't try somebody twice for the same crime, can you? They called a mistrial. Instead, they called a mistrial. And since it was a mistrial, they were able to try her again. Except the second time they tried her, she wasn't tried. They found her not guilty for reason of insanity. And she was remanded to a mental institution in Vernon, Texas. What do we know about Vernon, Texas? Well, you guys probably don't know anything about Vernon, Texas, but I used to teach there. Not at the institution. I used to teach at the junior college in Vernon, Texas. Vernon Regional Junior College. I know, it's kind of an interesting aside. And that's where she is. So I tried to figure out if she's still in the mental hospital. And she is. She's still in the mental hospital. And now, 15 years after she killed her children, now she's rueing the fact that she doesn't have her children to be with. Now she's sad that she no longer has children. What happened to Rusty? Rusty Yates, the husband. Anybody know? He got remarried and now he's got another pile of children. So there you go. He married a blonde. She's a brunette, of course. I don't know if that has anything to do with anything. But he's got another pile of children. Anyway. Okay, competence to stand trial. It refers to a defendant's capacity to function meaningfully and knowingly in a legal proceeding. Defendants may be determined by a judge to be incompetent if they are seriously deficient in one or more abilities. If they can't understand the legal proceedings, they don't understand what's going on. And actually, legal proceedings are relatively complex. So there's a lot of people that have a difficult time understanding what the hell's going on. If they can't communicate with their attorneys, for one reason or another, if they can't communicate with the attorney, if they need to appreciate their role in the proceedings. Of course, they are the one with all the information. They are the one that are being tried for whatever. So they need to understand where they fit into the proceedings. They need to make legally relevant decisions. The client has to make decisions. The first decision, of course, that they have to make is whether they plead guilty or whether they plead not guilty. It's an interesting situation if you plead guilty. You lose a whole lot of your rights. A whole bunch of things cannot happen if you plead guilty. Now, one of the things that happened on Monday, as exciting as it was, is that they filed charges against they filed charges against 2 people, and 1 person pled guilty. This is going to be fascinating to watch. So if you're interested in the legal system, what happened on Monday is going to be fascinating for you, because 2 people were charged with 12 counts of conspiracy. Treason is one of the, well, not really treason, but conspiracy to harm the federal government. Then they were charged with all this other stuff as well, money laundering and whatnot. It's going to be fascinating to watch this whole process. And we're going to see more indictments. So if you're really interested in the law or interested in the government or politics, wow. Right now there's just a ton of stuff that's going to be taking place. And we're really fascinated to watch who is the next guy to be arrested for collusion with the Russians. This is really kind of fascinating. Yesterday, who testified? Oh, all of the social media testified yesterday and disclosed all kinds of interesting information. 126 million Americans came in contact with some of this trolled stuff out of Russia. Fascinating stuff. So if you're interested in this stuff, right now is a really good time to be reading the newspaper, not especially the newspaper, it's the Gallup Independent crap. So, but you can see this stuff online. Watch Fox News or CNN, whatever you want to watch, NBC News. It doesn't really, yes it does, it matters. Because evidently Fox News isn't covering this stuff. So if you want to see what CNN thinks is happening, it's really kind of fascinating. A lot of fun stuff is going on. Collusion, yeah. So what's the difference between collusion and conspiracy? I know they had to define the difference between the two. Really kind of fascinating. The accepted national standard for competence to stand trial is a sufficient present ability to consult with one's attorney with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against one. One of the problems that people have is that they're not very well, relatively, there are a lot of people that are not very well educated. So do they really understand what's going on is the question. And the answer is maybe, maybe not. If they don't really understand what's going on, does that mean that they can't stand trial? That they're incompetent to stand trial? No. No. All they have to know, all they have to understand is the difference between pleading guilty and not guilty. That's all they need to understand. And this was determined in the case of Dusky versus United States in 1960. This is actually Dusky right here, which is kind of interesting. I don't know where I found the picture, but that is actually Dusky. 1960, a long time ago. The Dusky standard does not specify how the evaluator assessing competence should judge the sufficiency of rational understanding, ability to consult, or factual understanding. In order to really understand all this stuff, you just about have to be a lawyer. But so any of you in this room should be able to understand, if you were in a legal situation, you should be able to understand exactly what's going on. You have that level of intelligence, that level of understanding. You should understand. You don't have to be a lawyer. And this is one of the reasons why a lot of individuals, when they get arrested, if they go to prison, a lot of times they study the law. They study law books. So if you look at prison libraries, they're full of law books, usually state law books, dealing with their case. I have a friend who's has a relative that was convicted of murder, but it was a drug case, as strange as that sounds. But it was a drug case, and he dropped a dime on the other people in the case. And because of that, they were convicted. Well, there's a thing called Rule 35. Rule 35 says that if you were convicted of something and they made a deal with you before you testified, you always have to testify before they say the deal is intact. If that is the case, then potentially it will reduce your sentence, and that should be what has happened to this kid. But that's not what has happened. They haven't reduced his sentence, but he did comply with the legal authorities, and he did provide evidence against these other individuals who were convicted, who were eventually convicted. Of course, it's a murder trial; it's a capital crime. But according to Rule 35, he should have his sentence reduced, and I think he's in for 35 years. So we'll see what happens.
Is the deposition the same as the testimony?
I'm sorry?
The deposition the same as the testimony?
Deposition is the same as a testimony. Deposition is, deposition is written, and testimony is evidence against somebody. So you can use a deposition as testimony. Okay? So they can be the same thing. The testimony can either be written or it can be verbal. Okay? Okay. In a number of courts, the mental health groups have listed more specific criteria related to competence to allow evaluators to provide courts with more detailed information in these areas. And normally what will happen is that the defense will provide their psychologists and the prosecution will provide their psychologists. So there's a lot of work out there for forensic psychologists. Sometimes they'll present just one individual, sometimes they'll present more. It all depends on how much money they have, because these guys are relatively expensive. The more evidence that you have, the more likely that the judge will, or the jury will accept the decision. For example, evaluators may consider a number of relevant psychological abilities, understanding the roles of key participants within the legal process, the current charges faced by the defendant, the elements of an offense. And one of the problems, you would think, well, charges are fairly simple, aren't they? Well, if you read the indictment on Papadopoulos and Gates and Manafort, that's the guy's name, Manafort. Paul Manafort. Looks like my nephew. It just drives me crazy. He even walks the same way. It's nuts. He's got that goofy look on his face all the time. Paul Manafort. Anyway, if you read the charges against them, sometimes they're a little bit difficult to understand. I read both indictments on Monday, and I wasn't exactly sure what some of the, and I tried to interpret what they were talking about. And I'm afraid maybe I didn't get it quite right. So the charges aren't always cut and dry. Manslaughter, well, that's fairly easy to understand. But they charged him with two things that sounded almost identical as far as Manafort is concerned. If I thought about it, I would have written them down so I could talk about them. But so sometimes charges are difficult to understand. In the military, when you are court-martialed, if you're caught having sex with the wrong individual, one of the things they will do is charge you with, if you're not married to that individual, they'll charge you with copulation, which it's not against the law any place else except the military. You're not supposed to have sex with the wrong person, somebody that's not your spouse. If one of you is married, that's adultery, so they charge you with fornication. Fornication, and they charge you with adultery. If you're having sex other than in the genital sex or in the missionary position, then they charge you with sodomy, as strange as that may seem. So they charge you with all these different things, and you're thinking, wait a minute, I only had sex one time, but you're charging me with like 5 different things. This doesn't make any sense. So you have to understand the charge, and you have to understand what they're talking about. The elements of an offense, what you did, the consequences of conviction, what's going to happen if you are actually convicted, will you get parole, will you get probation, will they throw you in jail, will you get time served, what are the consequences of conviction, what does that mean as far as me getting to do things, like vote or get loans. You know, all of these things are things that you need to understand. If you are convicted of a felony in most states, and it has to do with the state, in most states you'll never be able to vote again because you have been convicted of a felony, so you can't vote. Now, oddly enough, you can run for public office, so you can be the mayor of a city and not be able to vote for yourself, as strange as that may seem. But it all depends on the state, of course. The rights waived in making a guilty plea, and of course we're going to talk about that in just a minute. That's one of the reasons why when Papadopoulos pled guilty, it changed just a ton of different things. Normally, even if you committed the crime and they've got tons and tons of evidence against you, usually you will plead not guilty. Even if it's obvious to everybody in the room, including the judge and the prosecuting attorney and your defense attorney, that you were the individual that committed the crime, you will still plead not guilty. And the reason you do that is because now you have the power to negotiate as to what's going to happen to you next. If you plead guilty, it's up to the judge as to what happens next. And you have no more rights. You can't negotiate. You've already pled guilty to this problem, or this crime. It gets really fascinating. So almost everybody pleads not guilty, so that they can negotiate what's going to happen next to them. Appreciation, the likelihood that he or she will be found guilty, the consequences of the defendant of being convicted, the defendant's appraisal of the available legal defenses and their likely outcomes, the defendant's appraisal of whether or not to testify. The individual doesn't have to testify in their own defense. As a matter of fact, most lawyers won't allow their client to testify. It's relatively rare for that person to get on the stand and for people to talk to that select individual. The defendant's ability to make rational decisions regarding this specific case. So that has to do with appreciation. Reasoning, to distinguish more relevant from less relevant information. Of course, there's tons of information out there. A lot of times people think, well, this little piece of evidence exonerates me, and in reality, it actually goes against them rather than exonerates them. To seek relevant information, what is relevant and what is not relevant. Defense attorneys, of course, can bury people in non-relevant evidence. Usually, the judge will stop them from doing that. This doesn't have anything to do with the case. Why in the world are you talking about the World's Fair of 1939? That doesn't have anything at all to do with this case. So, of course, they need to understand what relevant information is, to weigh and evaluate various legal options and their consequences, to make comparisons, to provide reality-based justification for making particular case-specific decisions or conclusions. Okay.
So, would that also be like would they did an affidavit?
They did an affidavit. An affidavit is a statement as well.
Yeah.
Okay, a deposition is where both lawyers, the prosecuting attorney and the defense attorney are both in there at the same time.
Yeah.
Okay, so that's what a deposition is. They can ask questions and that becomes part of the deposition. An affidavit is you just stating and writing it down that this is what happened. It doesn't have anything to do with the two lawyers.
So when you do the affidavit, that becomes something that a judge can rule on.
Right, exactly. Let me give you an example that just happened. Papadopoulos evidently went in and they deposed him. And when they deposed him, he wasn't truthful. Okay, so now it has become legal. This is all legal.
What do you mean by deposed?
Deposed? That means that his attorney was there and the prosecuting attorney was there, and they asked him specific questions.
Okay, so just questioning.
I'm sorry?
So just questioning him?
Yeah.
Okay.
And it was all written down. He wasn't in a court of law, so that made it a deposition. If it was testimony, that's in a court of law.
Okay.
If you sign an affidavit, that's only in front of one lawyer. That's in front of your defense lawyer, and you have stated that this is true. And if that affidavit is presented to the court, they will accept that affidavit. Now, whatever you said in the affidavit becomes a part of the process. It's been part of the court. So that's what Papadopoulos did, and they actually deposed him twice, and he lied both times. So the third time they had evidence that he had lied, and that was in July. And when they had evidence that he had lied, they said, we're going to charge you with obstruction of justice and collusion or whatever. Who knows what they actually said to him, but he decided, but they gave him an option. They said, if you plead guilty to lying to us, and if you help us, then something else is going to happen to you. We're not going to charge you. We're not going to send you to jail for 5 years like they would have otherwise. We'll only arrest you for 6 months, or put you in jail for 6 months, or something. We don't know what the deal was. We have no idea what the deal was. But we know that Papadopoulos was working with the government. Now all of a sudden he's collecting information, he's helping the government collect information against other people. You're talking about something specific and I'm talking about an example. Okay. Yeah. So an affidavit is where you swear in front of the lawyer that this is true. And so your lawyer will take that to the court and say, this is what they said. A deposition is where both sides get to question you and they write everything down. And everything that you said, you have sworn is true. So now if they find out that you have perjured yourself, if you have lied in court, the affidavit is a legal document, and so is the deposition. Now they can try you for perjury, or they can accuse you of perjury, and of course that will go to trial as well. So we have a situation where two individuals were arrested on Monday. They're on house arrest. They're white, of course. They're on house arrest. Instead of being in jail, they're on house arrest. And they pled not guilty, and then Papadopoulos, of course, has pled guilty. And we don't know what the deal was, but there was a deal going on. And we're going to find out what he lost by pleading guilty. Okay, I know you have a specific question, and I'm not. Am I answering your question?
No.
Okay. You need to assist in one's defense, consult with your lawyer, you need to relate to the lawyer, you need to be able to talk to this guy, this individual, you need to be able to relate to them. A rapport needs to be built between you and your lawyer. And I don't know how many conversations you've had with lawyers, but a lot of times they're really good talkers, but they're horrible listeners. That happens. My daughter talked to a lawyer, trying to pick a lawyer for her custody case, and the guy wouldn't listen to her. He just wanted to talk. So she didn't pick him as her lawyer. She found another person that would actually listen to hear what she had to say. She's a really smart kid. She's 49. I'm calling her a kid. She's 49 years old. Anyway, so she picked another lawyer. And as it turns out, the lawyer that she rejected was the lawyer that the father of the child used. And he still wasn't listening to anybody. And that's why they got blasted in the case, because he didn't hear anything that anybody was saying. He just wanted to talk. So this is when we talk about relating to your lawyer, that's what we're talking about. Does the person understand what's going on? Does he want to hear what's going on? He's tried 100 of these cases. Okay, this is a different case. I'm an individual. This is not your 97th case. This isn't your 46th case, which is very similar to your 23rd case. No, this is a completely different situation. And of course, sometimes they can't hear you. And you get this rather than this. This is what you want your lawyer to do, to be able to organize all the information. You need to be able to plan your legal strategy, engage in his or her defense. You need to challenge witnesses and testify relevantly if you need to testify. Manage your courtroom behavior, of course. In other words, you can't speak out of turn. You're only allowed to speak when you are asked questions. Most of the time you have to sit there and shut up, which is not easy for people. Once upon a time they had riots in Chicago. And the group of individuals that came in and created these riots, they put on trial. And they wouldn't shut up during the trial. So initially the judge told them that you need to muffle your clients. And they still wouldn't shut up. And they said, well, we're going to remove you from the court if you don't shut up. And so they would speak up, and of course they'd be kicked out. And of course they had to start the trial while they were gone. And they would charged them with contempt of court. Of course, they were already in jail, and they were staying in jail. That wasn't the problem. Eventually, they got to the point where they actually put a gag. A gag order is one thing, but they actually put a gag around these guys' mouth to keep them from talking during what was going on. And they started kicking the table. And of course, they tied their legs to their legs to the legs of the chair, trying to keep them quiet. Yeah, this is funny, Jeff. You can laugh all you want. Well, guess what happened next? Well, they were convicted, of course, because they were so disruptive in court. But that's exactly what they wanted. They were the Chicago Seven, the infamous Chicago Seven. As much fun as it is. So you need to manage your courtroom behavior. Decision-making abilities relevant to the decision likely to arise during the proceedings. All of these things are things that show your competence. The issue of competence also arises when defendants plead guilty. By pleading guilty, defendants waive several constitutional rights. And here you go. Now we're going to find out what Papadopoulos cannot do. Remember, he pled guilty. And he may be working with the feds, but at the same time, with Mueller, but at the same time, these are things that he can't get because he has pled guilty. He can't get a jury trial. He doesn't have the right to confront his accusers. Of course, his accusers are the people sitting across from him that he's helping. He doesn't have the right to call favorable witnesses. He has to remain, he doesn't have the right to remain silent. In other words, he has pled guilty. So now if they can ask him any question they want, and he can't plead the fifth. He can't say that I will not answer that question. He has to answer all questions. So what does this mean for the Trump administration? Whatever information Papadopoulos has, Mueller has. Because he can't not say something. He has made a deal. He has pled guilty. And whatever that deal is, it has to do with him giving them all the information that he has. And if he will not disclose any of that information, the deal's off. And he goes to jail for 5 years. He may have made a deal that he won't go to jail at all. He'll get house arrest for 6 months or something. We don't know. We have no idea what it is. But now he doesn't have the right not to answer a question. He no longer has the right to remain silent. Whoops. So everything Papadopoulos knows, Mueller knows. The Supreme Court has held that waiving such important rights must be done knowingly, intelligently, and voluntarily. And evidently that's exactly what happened with Papadopoulos. George Papadopoulos. Sounds too close to George Stephanopoulos. They're both Greek. So, okay. Anyway, George Papadopoulos. Who knows what's going to happen next? It's really fascinating. This is really a fun time to care about politics, because we'll see what happens with Trump's administration. Because potentially, they're talking about collusion with the Russians, which is a form of treason. So we'll see what happens. It's really fascinating. Or not. So you know who the president is today. You may not know who the president is tomorrow. We'll see what happens. The United States Supreme Court rules that the standard for competence to stand trial will be used in federal courts for assessing other competence questions. That was determined in Godinez versus Moran. And this is Godinez in 1993. Thus rejecting the idea that competence to plead guilty involves a higher standard than competence to stand trial. So in order to plead guilty, and we do have this problem, we have individuals that plead guilty to a charge when they don't have the ability, they're not competent. And of course, if that is the case, then they can't plead guilty, as strange as that may sound. So the standards for pleading guilty are higher than that for the competence to stand trial. So just because they pled guilty, just because they made a confession, It doesn't have to be accepted by the courts, as confusing as that is. This is just federal court. Every state has their own laws. There are 51, well, actually, District of Columbia follows the federal government standards. Now, what if you commit a crime on the reservation? What court do you go to? Federal court. You go to federal court. There is a problem with federal court, and this is one of the complaints that people have dealing with living on a reservation. This is a complaint. The problem is that if you live in Arizona and you commit a crime in Arizona and you are tried by the state court, then potentially you can be paroled by the state of Arizona or get probation by the state of Arizona. If you commit a crime on the reservation that is a felony and they decide to try it in federal court, they don't have the same parole that the state does. So if you are given 10 to 15 years, guess how long you're going to spend in jail? 10 to 15 years. There is no getting out on good behavior. However, if you had committed the crime in Phoenix, where they're potentially off the reservation, and you had been tried by the state of Arizona, then potentially you could be paroled by the judge. You get 10 to 15 and you only serve 3. They let you off for good behavior. And this is one of the problems with going to federal court. The parole system is completely alien to everything that everybody knows. So what if you're a Navajo and you commit a crime in Phoenix? Do they try in federal court? How about this? What if I am caught speeding out here? I got a parking ticket the other day. What if I'm caught speeding? Can they stop me and give me a ticket? Can the Navajo Nation police stop me and give me a ticket? Yeah, but I don't have to pay it. That's the strange part.
They don't forward to the DMV or something?
I'm sorry?
They don't forward to the DMV or something?
I'm not understanding what you're saying.
And if you use words, would they forward it to the state of Arizona?
They could do that, but the state of Arizona and the Navajo Nation don't communicate like that. So if I'm doing something really stupid, if I'm creating a dangerous situation, then potentially what can happen is the Navajo Nation police will stop me and they will keep me from doing it again, and they can call the state of Arizona. But they're not going to do that for a speeding ticket. They're going to do that if I'm driving dangerously. Then they'll call in the state of Arizona, and the state will waive rights for jurisdiction in their own area, and they will tell them what they were doing, and I will be arrested by the state police. Yes, that's a possibility. What if I decide that I'm going to give up, I'm going to jump off the wagon with a case of vodka? I'm not exactly sure how many bottles are in a case of vodka. So I load my Miata up with a case of vodka. Of course, this is a dry reservation, so what happens next? What are they going to do to me? And they stop me and they check my car, and they find out that I have a case of vodka. And I tell them, that's for my own personal consumption. I'm not going to sell any of that. I would never. I would not have to give that to anybody else. That's just for me. How long is it going to take me to drink a whole case of vodka? What's 12 bottles or something? What will the Navajo, can they arrest me? It's against the law to have booze on the reservation.
Confiscate it
They will confiscate it. They'll confiscate it.
for their own personal.
They can't incarcerate me. They can't charge me with anything, but they can call the state. Now the interesting thing, of course, the state's not going to do anything. I can have all the booze I want off the reservation. So it's only on the reservation that I'm in trouble, right? What else can they do to me? They can kick me off the reservation. They can tell me that I can't come back.
They're gonna come, Brian, we have you instructed over here.
And he's got this old case of booze, do you wanna come over?
Celebrate his rest.
Exactly. I know Brian Jones. Okay, we'll call him up. Let's have a big party. I don't drink, so we don't have to worry about that. And I drive very carefully and very safely. Almost. As a result, the terms, I drive 65 miles an hour like you guys suggested. And I get passed by like every junky pickup truck
Every
on the
blue
reservoir.
car?
Every blue car. And they are blue. They're always blue. I don't know why I get, and gray. Gray cars pass me too. As a result, the terms competence to plead guilty and competence to stand trial have become confusing. You cannot plead guilty unless you are especially competent. And of course, we assume that Papadopoulos, 30-year-old gentleman, is competent to plead guilty. And before they could, and this is one of the reasons why it took them so long to get him to plead guilty. He pled guilty in July. They caught him in March, and it took them until July to make the deal and to determine if he was competent to plead guilty. They had to determine that before they could get him to do that, before they could allow him to do that. As strange as that seems. Some have suggested that adjudicative competence is clearer than the terms competence to plead guilty and competence to stand trial. I don't know, adjudicative competence does not seem that much clearer to me. The question of a defendant's competence can be raised by any point, at any point in the criminal process, and it can be raised by the prosecutor, the defense attorney, or the presiding judge. A lot of individuals will act crazy after they've been arrested, and hoping that at some point they can use this, and then potentially, of course, they will not be prosecuted because they are incompetent. They are adjudged incompetent. Once the question of incompetence is raised, the judge will typically order an evaluation of the defendant, and this takes time. Okay, so all of a sudden I'm hiring, if I'm the defendant, I'm going to hire a forensic psychologist to evaluate me, and the prosecution is going to do the same. So let's say that I hire somebody that tells the court that I'm nuts, and the prosecuting attorney hires somebody and they say that I'm sane. Guess what's going to happen next? They will hire somebody else that will say that I'm insane. And then the defense will hire somebody else that says I'm insane. And we keep doing this until somebody runs out of money.
What about history?
I'm sorry?
History?
History?
The history of...
If I have a history of
Yeah.
insanity, that will
That will
work.
work.
Yeah, that will
Okay.
work. But see, we've got that shooter in Las Vegas, and we got no history on this guy. What's gonna, he's dead, of course, and we're not gonna try him for anything. But he has no history. So unless you've been to see a psychologist, a counselor of some kind, a social worker, anybody that will say, wow, he was kind of off his rocker about 15 years ago. Unless we can find that individual, unless we have that in our background, unless it's written down someplace, we got no luck. We don't have a history of this. Now we can go and talk to our employers, and if I was fired for erratic behavior, then that is a history. Then potentially that will work, as strange as that seems. Here's a guy from Arizona, Jared Loeffner. He had a history of bizarre behavior. He had been expelled from Pima Community College for classroom outbursts, kind of like Brian. I can't shut him up. He's a cool looking guy, isn't he? He posted bizarre things on the internet. If you read his social, this is one of the interesting things about Papadopoulos. He was talking on Facebook about meeting with Russians, and then he claimed that he didn't meet with the Russians, and he tried to do away with his Facebook page. I know. How stupid do you have to be? Can you do away with your Facebook page? No. It doesn't ever go away. On 8 January 2011, he entered a political rally. He killed 6 people, and he wounded 13. One of them was the U.S. congressman who he shot in the head.
Shot in the head? Oh,
Yeah, he thought he killed her. I think she was the first one he shot, too, if I'm not mistaken. She was the one he was trying to kill.
was that the one in Tucson?
Yeah, Tucson.
Was that a Smith's?
Giffords is the lady's name. She was married to an astronaut. My goodness. Psychiatrist testified in a competency hearing of Loeffner. He suffered from random and disorganized thoughts. He experienced delusions. He answered questions in an irrelevant fashion. They diagnosed Loeffner as having schizophrenia. Loeffner has been remanded to the Federal Medical Center in Springfield, Missouri. And he looks crazy in this picture.
So he was diagnosed after that?
Yeah, they diagnosed him afterwards.
I wonder how many get
But he has a history of
diagnosed afterward.
bizarre behavior. I'm sorry.
I wonder how many people like that get diagnosed until afterward. You know what I mean?
We should not get diagnosed until after. He has to do something before anybody cares. You know, we're not going to say anything about Bryant just because he speaks out in class.
I forgot my Cocoa Puffs.
I didn't have any caffeine this morning. In your case, it's chocolate. So. Cocoa Puffs, of course. Cocoa Puffs. He looks crazy in this picture. Now, the strange thing is that, and of course, he's not going to be, he murdered 6 people. So potentially, in this state has capital punishment, right? You guys execute. Yeah. So potentially, 6 people. Why wouldn't he be executed? Well, it's because he's nuts, right? Isn't he? You can just look at him and tell that he's crazy. Can he fake being crazy?
Yeah.
Can he look crazy like this?
Yeah.
Is that a possibility? Sure. Okay. Well, at least he's not going to die. He gets to live for the rest of whatever his life is. He's not in prison. He's in a lockdown medical facility in Springfield, Missouri. Maybe this is better than doing hard time. Maybe. I don't know. I've never done hard time before. So. Most evaluations over the last 2 decades have been conducted in the community on an outpatient basis. Physicians, psychiatrists, psychologists, and social workers are authorized by most states to conduct competence examinations. The psychologists are responsible for the most reports. Usually it's a psychologist, and usually you have to have a PhD. If you're a social worker, you have to be a licensed clinical social worker, LCSW, or you have to have a master in social work. And all social workers are counselors, as it turns out. So if you are a social worker, all you need is a master's degree. You need to be a licensed clinical social worker. As exciting as all that is. Why do I know this? Because we're trying to hire somebody to teach social work. And we keep coming across social workers with a BSW, Bachelor in Social Work. The individual that we want has to have a master's degree, just like most college professors are PhDs. As far as social work is concerned, almost all social workers never get beyond a master's degree, unless they want to teach, and then they can get a PhD. So we're looking for a licensed clinical social worker. Having mental illness or intellectual deficits does not guarantee that a defendant will be found incompetent to stand trial. Just because you have been diagnosed with a problem, he was depressed, he has anxiety, he's kind of paranoid. Just because you've been diagnosed with this stuff doesn't mean that you can't stand trial. Which is actually what happened with Andrea Yates. She was very lucid. She was extremely lucid. That's potentially what would have happened with the shooter in Las Vegas, who I keep wanting to call Pollard, but his name isn't Pollard. It's something else. It's a very common name. And I keep telling every time I see it, I say, you should remember this because it's similar to something else, but I keep wanting to call him Pollard. And his name isn't Pollard. Anyway, yeah, there's nothing wrong with it. I mean, potentially nobody saw anything wrong with this guy. He was a recluse. But he walked around Las Vegas and nobody even paid attention to him. So is he competent? Would he be competent to stand trial? If he's completely lucid. If he's well-spoken. That's what happened with Ted Bundy. Ted Bundy was a very well-spoken individual. As a matter of fact, he studied law for a while. As odd as that seems. Several instruments are available to assess the capacity relevant to competence to stand trial. One of them is the interdisciplinary fitness interview. There's a new revision of the old test. It's a semi-structured interview that evaluates a defendant's abilities in 5 specific legal areas, and it assesses 11 categories of psychopathological symptoms. How long does it take to do this? A couple of hours. Now the reality is that you guys have a hard time sitting in those chairs for the hour and 30 minutes or however long, the 20 minutes that I have to torture you. So you can imagine how bad it is for somebody that has to sit there for 2 hours. You should all feel sorry for Curtis because he's got the class right before you, and he has to listen to me for an hour and 20 minutes before you guys even come in. So the poor guy is sitting there for 2 hours and 40 minutes, suffering. He hates my voice, can't stand my voice, and here he has to listen to me for 2 hours and 40 minutes. So you can imagine how hard this is. By the end of an hour and 20 minutes, you're already starting to pull your hair out. Yeah, okay. So you can imagine how hard this is. Jeff's in the same situation. He's going to go bald if he keeps taking my classes. Don't take my classes next semester, Jeff. You're not going to, are you? No, you're not. The fitness interview test, revised, is a structured interview for assessing a person's competence to stand trial. I'm going to give you several different tests that they use. They all take about 2 hours. Some of them take up to 3 hours. They are all these set pat questions that you ask these select individuals. So this is something that you have to remember. It includes 16 items in 3 broad domains: factual knowledge of criminal procedure, appreciation of personal involvement in and importance of the proceedings, and the ability to participate in your own defense. And this is this test. Let's do another one. The MacArthur Structured Assessment of Competence, of the Competence of Criminal Defendants. There's actually 2 forms of this, aren't there? There are 2 forms. There's a CD form and there's another form, a CI form, I think. It consists of a vignette about which the defendant is asked 82 questions that tap foundational and decisional abilities. It takes 2 hours to complete. That's if the person doesn't think. CA, that's what it is. The MacArthur Competence Assessment Tool Criminal Adjudication is a shorter version of the MAC-SAC CD. It too begins with a hypothetical vignette about a crime. Items assess the defendant's understanding of the legal system and adjudicative process and his or her reasoning abilities in the legal system and legal situations. Other items are specific to the defendant's own legal situations. But we're not done yet. We got another one. The evaluation of competence to stand trial, revised, and that's what it looks like. It was written by 3 PhDs. Of course they were PhDs. It's a semi-structured interview that was developed using the Dusky criteria, assessing factual and rational understanding of proceedings and consultation with counsel. It focuses on information that is specific to the case of the individual being evaluated. It addresses the question of whether the evaluee is trying to exaggerate or fake deficits that might make that person appear incompetent to stand trial. And of course, these are just 4 different tests, but we're not done yet. We've got another one. The competence assessment for standing trial for defendants with intellectual disability. This is a picture of an individual that left her baby for 2 days. And when they went in to check on the child, when she went home, she found the child dead. And they actually tried her and convicted her. And her father Her father forced the courts to re-adjudicate, to look at this look at the situation again. And when they did, they realized that her IQ was relatively low. It was in the 80s, 82, I think. And when they determined that, they realized that she probably wasn't competent to stand trial. So they threw out her old case, they retried her, and they found her incompetent to stand trial. That's what they did. So she was remanded to a mental institution. But what happened was, she was a party girl, as odd as that may seem, and she lost track of time, and she forgot that she had a child. And when she went in to check on the child had died. Anyway, interesting case. So in order to determine that, now they have a test to determine if they have the intellectual ability to stand trial. They have a test for that as well. And if you look at this picture, you'd say, well, she looks like she has a problem. Her eyes are kind of glazed over and they're only half open. She's either really sleepy or she's got a problem, looking at the picture. I have other pictures of her where she doesn't look so confused. Estimates of malingering, faking, or grossly exaggerating mental illness in competence evaluation are close to 18%. You can fake it. Lots of people try it. And they are successful about 18% of the time. Very poor performance should make evaluators suspicious that a defendant might be exaggerating their deficiencies. The Miller Forensic Assessment of Symptoms test is a 25-item structured interview that can identify individuals who are attempting to feign mental disorders. We have these tests that will tell us if there is a problem. And usually you ask them the same question twice. And the second time you ask it backwards. That's the way it works. They do the same thing in the MMPI, the Minnesota Multiphasic Personality Inventory. They will ask you the same question that you should answer the same way 2 times. But the first time they ask you the question straight up, and the second time they ask it backwards. And if you're really thinking about what you're answering, you will answer the question exactly the same way, despite the fact that they have reversed the question. And if you don't, then they know that you're lying. So there are lying scales in the MMPI. Following assessment, evaluators usually give a written report to the judge that summarizes the evidence on competence to stand trial, as well as the likelihood that appropriate treatment will sufficiently improve competence-relevant deficits. What will happen is if they determine that you have a problem, they will try to do something to make you competent. They will try to treat you in one way or another so that you can stand trial. They'll do everything they can to get you to be able to stand trial. Sometimes there is a formal competence hearing where the evaluating experts testify and are questioned by attorneys from both sides. And of course, we've got people on both sides usually. And one will say yay and the other will say nay. So now we need to go to a third, or they will just bring in an adjudicator, somebody that will negotiate between the two. Following assessment, evaluators usually give a written report to the judge that summarizes the evidence on competence to stand trial, as well as the likelihood that appropriate treatment will sufficiently improve competence-relevant deficits. One of the things that will happen if you are a forensic psychologist, when you go into to question the individual, you will do it without, the defense attorney won't be there, the prosecuting attorney won't be there. You will be allowed to query the defendant by yourself. And of course, then you'll write a report. Whether you've been hired by the defense or whether you've been hired by the prosecution, it really isn't supposed to make any difference. You're supposed to be truthful about your adjudication, about how you feel about this select individuals. And a lot of times, of course, if they are competent psychologists, you'll get the same answer from all of the different expert witnesses. You should get the same answer. If Ryan and I go in to see a defendant and we give them the same instrument, of course if we give them different instruments, maybe your instrument is a little bit more sensitive than mine is. But we should, as ethical psychologists, we should get exactly the same answer, theoretically. And that's the way it works. Usually that's the way it works. So whether you've been hired by the defense or hired by the prosecution, potentially I should get the same answer that Brian gets. Sometimes there's a formal competency hearing and anyway, and actually we can be brought as expert witnesses by both sides. And theoretically, they should question both of us. Theoretically, I am a member of the court, so I am not a defensive expert witness. I'm not a prosecuting expert witness. I am hired by the court. Potentially, I am. It all depends on the state that you're in as to whether you are hired by the defense and the prosecution or by the court. Normally, a court will not use just one forensic psychologist. Normally they'll use at least two, sometimes they'll use three, especially if they get conflicting reports from the two individuals. In formal competence hearings, who bears the burden of proof? A state can require a criminal defendant to prove that he or she is incompetent, which means they have to hire the individual to show whether they're competent or not. That way the state doesn't have to pay for it. That's a pretty good deal. Most states establish the criteria to be a preponderance of the evidence, meaning that the defendant had to show that it was more likely than not that he or she was incompetent. And of course, it all depends on the state, and that's what we're looking for. About 70% of defendants referred for evaluation are ultimately found competent to stand trial. 70%. It is relatively rare for somebody to not be considered competent to stand trial. Loeffner was not. But almost everybody. The guy in Colorado that shot up the theater in Colorado, despite the fact.
James Holmes.
Holmes, yeah, Holmes. He stood trial, despite the fact that he dyed his hair orange and acted just as goofy as Loeffner did. He was determined. It was determined that he was competent to stand trial, and he did, and he got life in prison. When very rigorous examinations are conducted, the rate approaches 90%. So sometimes this is done kind of haphazardly, and in those cases, sometimes they are not able to stand trial. But if they use very rigorous examinations, it's 90%. What sort of person is most often judged to be incompetent? Nicholson Kruger in 1991 found the typical defendant to have a history of psychosis for which previous treatment had been received. That's what Kristen was talking about. Exhibit symptoms of current serious mental disorder. So other people have stated that this individual is acting erratically. They're single, unemployed, and poorly educated. Less likely to stand trial. They perform poorly on specific competence assessment instruments. Do I have time to do one more? Yes. For those found competent to stand trial, the legal process resumes. For those found incompetent to stand trial, the charges are occasionally dropped, especially for less serious crimes, sometimes in exchange for requiring the defendant to receive treatment, of course. And this is what Loeffner looked like when he was at Pima, and this is what he looked like after he shot Giffords, all those people, killed all those people. So as you can see, he looks fairly lucid here, but here he doesn't at all. Okay. I'll see you guys next week. After I finish chapter 10, I will write the test. I'm actually writing the test right now. So we will have a second test after chapter 10. This is what, the 11th week? Yeah, 11th week. So next week's the 12th week. It's the way the world works. 12 comes after 11, and then there's 13. And then there's Thanksgiving. Okay, I can count. And then the last week, the 15th week, is the week after Thanksgiving. So that's the last week.
Remember, you can leave Monday.
Monday?
22nd, the 20th.
I'm going not be here on the 22nd.
Oh, no, but you can go on the 20th.
You want me to leave early? You want me to get fired? I don't think he cares if I. Oh, I. So, oh.